Welcome to a presentation regarding misapplication of payments by contractors in Louisiana. Now, the criminal charge of misapplication of payments in Louisiana must be proven by the state prosecutor, and the following elements must be proven, which are the existence of a contract to build or any other kind of construction, the receipt of money or draws on the contract, and also a knowing failure by the contractor to apply those draws or money received to settle claims for material and labor due under the contract. So the penalties for misapplication of payments vary based on whether or not it's a misdemeanor or felony. It'll be a misdemeanor if the alleged amount of the misapplied payments is $1,000 or less. Therefore, the sentence and range for imprisonment is not less than 90 days nor more than 6 months. It becomes a felony if the misapplied funds is greater than $1,000. And therefore, we're looking at a sentencing range of imprisonment of not less than 90 days nor more than 6 months, or both, for each $1,000 in misapplied funds, provided the aggregate imprisonment shall not exceed 5 years. So like I said, the burden of proof rests on the prosecutor to prove that the defendant committed misapplication of payments, just like in any other criminal case, and the standard of proof is beyond a reasonable doubt. Sometimes the prosecutor will try to use circumstantial evidence. This is different than direct evidence, such as eyewitness testimony, DNA testing, or fingerprint analysis testing. That kind of proof is more direct versus circumstantial evidence, which in these cases prosecutors try to use a lot. However, the evidence must exclude every reasonable hypothesis of innocence. Let's do an example. Let's say ABC Builders, for example, contracts with John Smith, the homeowner, to build a 2,000 square foot house for $150,000. Well, that's not a whole lot of money. And let's say all the draws are complete from the homeowner to the builder. All inspections passed, certificate of occupancy is obtained. However, there are liens by the subs placed on the house for $20,000. And the reason is ABC didn't pay. So can the state prosecute under the statute? Well, it depends. It depends on the facts. Misapplication of payments by a contractor requires more than simply proof that a contractor has left unpaid claims for materials and labor. Simply inadequate bookkeeping, negligent supervision, poor calculation costs, disputed charges, cost overruns, it's not criminal. As long as the contractor applies all the money that he receives to the job, then he should be clear of the charges. The contractor could have initially underestimated the labor and material required. Could have been construction delays, increased labor and material costs. There's other reasonable hypotheses of innocence here. So since the prosecutor must prove beyond a reasonable doubt that the contractor knowingly failed to apply these jobs, he's got a heavy burden of proof. So the evidence must exclude these other reasonable hypotheses of innocence to support a conviction. So if you're a contractor and you're faced with one of these charges, we'll see if we can find a defense for you. Or if you have any other kind of criminal charge or any other contractor issue, feel free to give me a call.